Hey, I'm estate planning attorney Paul Rabelais, and in this video, I'm going to describe a problem I see over and over, as well as how to fix it. So in this video, I'm going to describe the relationship between the provisions listed in a will or living trust versus how someone designates their beneficiaries on an IRA, 401k account, or life insurance policy. You see, it's well known in estate planning circles that the beneficiary designation on an IRA or a life insurance policy supersedes anything written in the IRA owner's will or living trust. And while I'd say all reputable estate attorneys recognize this concept, many people in the public do not. So here's where that problem rears its ugly head. Let's say dad dies and had named mom as the 100% primary beneficiary of his IRA. It's common for married people to name their spouse as their primary beneficiary. So after dad dies, 70-year-old mom brings dad's death certificate to the financial institution that holds dad's IRA, and the financial institution moves all of dad's IRA into a new IRA that's in mom's name. And as part of the routine IRA account opening process for mom, the financial institution asks mom to designate the beneficiaries of the IRA when mom dies. And like most moms with two children whose husband has passed away, she designates her two children as 50-50 beneficiaries of her IRA. And since dad died, 70-year-old mom felt that she needed to update her will, so she does, leaving her entire estate to her two children 50-50. But a few years later, when mom is about 80, she starts to get frail. She breaks her hip, or she fractures her spine, or she gets in a car accident, whatever the issue may be. One of mom's two children, let's say the daughter, steps up and goes to mom's house every day to see to mom's needs. And mom's son doesn't lift a finger for mom. It doesn't really matter what son's reasons are. He doesn't have time. It would be a financial strain on him. He lives too far away. His relationship with his sister is not good. He's in an unhealthy mental state, whatever. Well, this neglect that mom gets from son upsets mom. And while mom doesn't want to totally exclude her son from her estate, she does want to change how her estate gets distributed when she dies. So she calls the friendly lawyer down the road and says she wants to change her will. She tells the lawyer, "I want you to rewrite my will so that when I die, my two children can share in the proceeds of the sale of my house, but I want all of my money and all of the rest of my estate, including all of my investments, to go solely to my daughter." You see, mom isn't very sophisticated when it comes to estate issues. Dad handled all of this while he was alive. So she did what she thought she needed to do to change her estate distribution. And her lawyer friend down the street simply did exactly what mom requested. He rewrote her will to say exactly what she wanted. Well, mom dies at 87 years old, and son soon thereafter becomes aware that mom had changed her will to declare that daughter gets all of mom's financial assets. And of course, the you-know-what hits the fan. Son immediately throws a fit, threatens lawsuits alleging that daughter adversely influenced mom into changing her will, blah, 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 blah. The future relationship between son and daughter will never, ever be amicable again. A couple of weeks after mom dies, the death certificates come in, and daughter takes the will and a copy of mom's death certificate to the financial institution that holds mom's $1 million IRA. And the financial advisor or representative of the financial institution that holds mom's IRA looks at their records and says, so I see that when your mom set up this account 18 years ago, she named her two children as equal beneficiaries. So why don't you go get your brother and come back so we can divide this $1 million IRA between the two of you? Well, daughter immediately proclaims, well, I see where mom designated me and my brother as beneficiaries 18 years ago on the initial account opening paperwork, but 4 years ago, mom redid her will, and in that will, she said she wanted all of her investments and all of her financial accounts to go to me, the sister says. Daughter. My mother didn't want my brother to get any of this $1 million IRA, and what you're saying is not what Mom wanted. Look at her will. And the financial institution appropriately responds with, I checked with our legal department and they told me that as it pertains to your mother's IRA, the beneficiary designation controls. The will only controls those assets that must go through probate, and your mother's IRA is a non-probate asset. The beneficiary designation on our financial institution's paperwork supersedes anything written in your mother's will. So the moral of this story is that anytime you change how you want your estate distributed, especially if you want to exclude a child or other person that was previously listed as a beneficiary when you opened a retirement account or initially purchased a life insurance policy, make sure you not only change the relevant provisions of your will or living trust, but also do a brand new beneficiary designation form with the appropriate financial institutions or insurance companies. Now, in this video, I did not dive deep into how IRA owners have the ability to name their estate or their living trust as the beneficiary of the IRAs and other non-probate assets. But naming an estate as the beneficiary of an IRA, while the distribution would follow the terms of the will, it would require that income tax likely be required to be paid much sooner than if the IRA owner had named individuals as beneficiaries of the IRA. And so while it's commonly understood and accepted in estate planning circles that a beneficiary designation supersedes the terms of a will or living trust, I suppose I'll need to periodically mention this in videos so that the average person who rarely, if ever, deals with estate planning concepts will be able to make informed and accurate decisions regarding how to leave their estate to their loved ones. We'll see you next time.